Lecture 3. Acceptance, Revocation. General principle. Silence cannot be used as a means to accept an offer. Feldhaus and Bindley, 1863. Facts. Feldhaus, the claimant, talked about buying a horse from his nephew. Feldhaus wrote to his nephew Bindley, stating, "If I hear no more from you, I shall consider the horse to be mine at £30. The nephew did not reply, no money was paid, and the horse remained in the nephew's custody. The nephew took action to contact an auctioneer in order to withdraw the horse from an auction. The auctioneer forgot these instructions, and the horse was sold to a different person. In order for the uncle to make a claim against the auctioneer, he had to demonstrate that a contract was in place between him and his nephew Bindley. Ratio. The Court of Common Pleas held that no contract existed. Feldhaus's letter provided an open offer, and it had not been accepted. Application. Silence does not amount to acceptance of an offer. The offerer can ask for a specific method of acceptance. General principle. If the offerer requests acceptance through a specific mode, then acceptance can only take place through this mode of communication. Tin and Hoffman, 1873. Facts. The claimant wrote to defendant to make an inquiry as to how much it would cost to buy 800 tons of iron. The defendant replied, saying that it would cost £3 per ton, and requesting the claimant respond by return. Ratio. The court held that, as the offer was not actually accepted by return of post, no contract existed. Application. Honeyman, on the other hand, stated abita that a telegram, communication verbally or any other kind of communication, that was at least as fast as a letter written by return of post would have sufficed. With this in mind, if an offerer asks for acceptance by post and the offeree sends acceptance through text message, a contract could be held to exist. General principle. The method of acceptance arranged for a tender was not mandatory, and if an offerer wants it to be mandatory, this needs to be made explicit. Manchester Diocesan Council and Commercial General Investments, 1969. Facts. The claimants, the Diocesan Council, owned a property that they wanted to sell by tender. The tender form included an additional statement that the tenderer whose application was successful would be notified by letter. It was to be sent through the post to the address that was written in the tender form. The defendant sent in a tender that the council then accepted. In September, they notified the defendant's representative of this acceptance. The Secretary of State gave permission for the sale to go ahead in November. During January, the claimant wrote to the defendant in order to provide confirmation of the agreement. The question that arose was when a contract had been formed. Ratio. The court held that a contract was formed in September. This was because the way in which acceptance could be carried out, as written in the tender form, was not limited as the only way of doing so. As such, the postal rule would not apply. However, any other means by which the claimant's acceptance was communicated would be satisfactory. Acceptance can be by conduct. General principle. A contract can be formed in absence of a written agreement if both parties' actions are in accordance with the agreement. Brogden and Metropolitan Railway Company, 1877. Facts. For several years, Brogden, complainant, had supplied the railway company, the defendant, with coal in the absence of a written agreement. The parties decided to enter a written contract. A draft contract was prepared and then sent to the complainant. The complainant amended it and marked it as approved before returning it to the railway company. Their agent put the draft in his desk. Business continued between the complainant and the defendant. The two parties maintained the trade arrangements under this new document until December 1973, at which point Brogden refused to continue to supply coal on that basis. He stated that, since the railway company had never actually made an alternate draft, which they intended to be a counteroffer, there could be no legal contract. Ratio. The House of Lords held a contract did materialize through the parties' actions that they carried out. The offer was the company ordering coal, and the acceptance was Brogden supplying it. Application. Actions between the parties can amount to a mutuality of obligations being fulfilled, even in the absence of a written contract. The Battle of the Forms. General principle. When accepting a contract, the agreeing party accepts the terms and conditions of the offerer. This is also known as the last shot rule. Butler Machine Tool Company Limited and XLO Corporation Limited, 1979. Facts. The sellers responded to the buyers, who were interested in purchasing a machine, by sending them a quote as to how much it would cost to supply it to them. The quote was given on the conditions that the sellers gave. These, it was written, were to be followed above any other terms and conditions that the buyers put in for their order. These clauses contained a price variation clause. The buyers made an order, but the letter they sent contained a number of contradictory conditions. In particular, they did not put in a price variation clause. At the bottom of the order was a tear-off confirmation slip that had been put in on the intention of the buyer's terms. The sellers completed this tear-off confirmation slip and sent it back. The sellers then asserted that they would now be allowed to make variations to the contract price. Ratio. The Court of Appeal rejected this claim. Their reasoning for rejecting the claim was that the sellers had willingly and expressly accepted the buyer's terms on the tear-off slip. They had accepted the buyer's last shot. Lord Denning stated, "In some cases it is decided by who gets there first. If the offerer intends to sell at a named price on the terms and conditions stated, and the buyer orders the goods intending to accept the offer, if the difference is so material that it would affect the price, the buyer ought not to be allowed to take advantage of the difference unless he brings it to the attention of the seller." Application. When a party communicates acceptance to an offer, he impliedly accepts the terms and conditions of the offerer. The postal rule. General principle. As soon as acceptance is posted through the mail, a contract is formed. This is known as the postal rule. Adams and Linsell, 1818. Facts. Linsell wrote to Adams, hoping to sell Adams some wool. He requested a reply to be sent in course of post. The letter containing the offer was sent out on the 2nd of September. It did not arrive, however, until the 5th of September. On the 5th, Adams posted back a letter containing his acceptance. When the letter actually arrived to Linsell, quite a long period of time had passed. Linsell had since assumed that the offer had been turned down, and he sold the wool to a third party. Adams brought a claim for breach of contract. Ratio. The court said Adams was to be awarded damages. The court ruled that Adams accepted when he posted his letter. Application. Postal rule dictates that a contract takes place as soon as the letter is posted, regardless of whether that letter reaches the offerer in time. The offerer, if he allows acceptance through the post, is held responsible for contracts he may have formed, but may not be aware exist. General principle. If acceptance is communicated through a letter that then becomes lost in the post, a contract will still be seen to have formed at the moment it is mailed. Household Fire Insurance and Grant, 1879. Facts. Grant took an interest in potentially buying shares in the plaintiff's company. The company was content with the application and sent Grant a letter in the post stating this, but it got lost in the postal system. The company liquidated soon afterwards. The liquidator, acting for the company, brought action against Grant in relation to any outstanding balance on the shares. Grant disputed the fact that he had to pay. He said he did not have to because he had not received a reply to his offer to buy the shares. Ratio. The court held that a contract came into existence the moment the letter of allotment of shares, the acceptance, was posted. Application. The postal rule still applies if the letter which communicates acceptance is lost in the post. Similarly to Adams and Linsell, a contract is formed as soon as the letter is mailed. The fate of the letter has no effect on the validity of the contract. The postal rule and instantaneous communication, i.e. email. the rapid expansion of means of electronic communication has brought up challenging and, as of yet, not fully addressed questions concerning how the postal rule applies when people communicate using email and any other messaging forum or medium on the whole internet, like Facebook and Twitter. On one side of the coin, there are those who argue that an email exchange is more or less simultaneous and instantaneous, and because of this, the postal rule should not apply. What this does not take account of, however, is that emails are occasionally rejected by server service providers such as Google or a private server for a company. Even if it does arrive, the recipient of the message might not actually read the message straight away. Many academic commentators have, on that basis, leaned towards the view that email ought to be treated as a kind of mail to which the postal rule should normally apply. This would, of course, be subject to when there is expressly agreed upon exclusion of the rule by the parties themselves. It is imperative to remember that the postal rule, should it even be able to be applied, applies to acceptances alone. It does not apply to an offer that has been communicated by post that is being revoked. It is a common misconception that an offer can be revoked by letter at the time it was put into the postbox because of the applicability of the postal rule. As such, the main applicable principle in the postal rule is that acceptance by post comes into effect when it is posted, as opposed to when it is delivered. When an offerer establishes a website that has a reply form included on it, a near instantaneous means of communication is achieved. This is because the offeree can immediately learn as to whether his acceptance has been received or not. There are a lot of theories that advocate that the postal rule should not apply in these situations, and a quite sustainable view that a web page, like a shop window, normally amounts to an invitation to treat as opposed to an offer. However, because the internet facilitates such an expanding means through which people can communicate, there are strong policy reasons that exist to make sure that the rules for accepting offers electronically are consistently the same, regardless of which kind of software is in operation. We have addressed this issue in a full answer in our question and answer lecture. Communication of acceptance. General rule. The postal rule cannot be relied on in cases where acceptance mandates actual notification or communication. Holwell Securities and Hughes, 1974. Facts. Holwell Securities, the claimants, were allowed by the defendant to have an option exercisable by notice in writing to Hughes, the defendant, at any time within 6 months from the date hereof. On 14th of April 1972, Holwell Securities gave notice to Hughes in writing as a means of invoking the option. However, the letter never arrived. The claimants, Holwell Securities, applied for specific performance of the option they agreed with the defendants. They argued that it was complete on 14th of April, which is when the letter confirming acceptance was posted. Ratio. The courts held that Holwell Securities had not legitimately exercised their option. Application. If acceptance requires actual notice, the notice becomes a term of acceptance. Applying postal rule in these cases results in absurdity, as it would violate terms of the offer. As such, postal rule can be set aside. When is acceptance communicated? General principle. An acceptance via instantaneous communication is not bound by the postal rule. Acceptance must be communicated for it to create a binding contract. Entors and Miles Far East Company, 1955. Facts. The claimant was a London-based company. They offered to buy, through the use of telex, goods from the defendant's agent. The agents were located in Amsterdam. Their offer was accepted by the defendant's agents, again through the use of a telex. As there was a dispute between the parties, the location where the contract had been concluded became very important. Ratio. The court held that since the acceptance was received in England, when the acceptance was sent via telex and read in England, Lord Denning reasoned that acceptance could not create a binding contract until it notified the offerer. Application. The onus, responsibility or burden to actually prove something, is on the person accepting to shout back, "I accept your offer," repeatedly until he is heard. Denning utilizes many examples to demonstrate this rule. If two men are separated by a river and one attempts to notify the other of his acceptance of an offer, but he is drowned out by the sound of a passing plane, it is his responsibility to voice his acceptance again to create a contract. Because of entors, no acceptance outside of the post can be valid unless it actually notifies the offerer. Revocation of offer. General principle. An offer can be withdrawn at any time before it has been accepted. Anything said or done to accept the offer after it has been withdrawn has absolutely no effect whatsoever. Routledge and Grant, 1828. Facts. Grant, defendant, made an offer to rent Routledge's, complainant's, building. A definitive answer had to be provided to Routledge within the space of 6 weeks. After 3 weeks had passed, Grant retracted his offer. However, just within the 6-week period, Routledge decided to accept it. Ratio. The court held that in this case, the acceptance had come too late. He reasoned that if one of the parties had 6 weeks to accept an offer, the other had 6 weeks to put an end to it. One party cannot be bound without the other. Application. Withdrawal usually needs to be communicated to the offeree. This does not become effective until this kind of communication to withdraw is received. The special rule for postal acceptances is not something that applies to withdrawals. General principle. Revocation of an offer must be communicated and is effective upon its receipt. Byrne and Company and Leon van Tienhoven and Company, 1880. Facts. Byrne posted a letter on the 1st of October with an offer to sell van Tienhoven a certain amount of tin plate. Byrne then posted another letter on 8th of October intended to be a statement to withdraw the offer. The first letter reached Tienhoven on the 11th of October, and Tienhoven accepted the offer immediately through the use of a telegram. They followed this up with a confirmatory letter 4 days later. The second letter sent by Byrne as a withdrawal arrived on the 20th of October, by which time the offer had been accepted. Ratio. The court ruled that Byrne's revocation was not valid until it was received by van Tienhoven. Thus, a contract had formed when van Tienhoven telegrammed his acceptance. Application. These kinds of promises cannot be enforced unless they are supported by some kind of consideration, something of value like money in return. General principle. The revocation of an offer does not have to be communicated by one party to another directly. It can be done through a reliable third party. Dickinson and Dodds, 1876. Facts. Dodds extended an offer to sell his house to Dickinson. He left the offer open until Friday. On Thursday, Dickinson made a decision to buy the house. He then heard from someone else that Dodds had entered into a contract with a third party for sale. On Friday, Dickinson accepted the offer. He then looked to enforce the agreement. Ratio. The Court of Appeal held that the information that was provided by a neutral and trustworthy third party about the house being sold was seen to amount to sufficient notice of the withdrawal of the offer for sale. Therefore, his acceptance was not effective. Application. Revocation of an offer does not need to be communicated directly. It is acceptable that the offerer was aware of the revocation of the offer before there was acceptance. General principle. If it can be demonstrated that revocation was sent and could have been reasonably read, then that revocation is valid. Tenax Steamship Company and owners of the motor vessel Brimnes, 1975. Facts. Tenax Steamship hired a ship named the Brimnes under the condition that the payment be prompt and paid in advance. When the payments arrived late, the owners withdrew their offer, as they were entitled to under the agreement. They issued this withdrawal via telex, and no one in the office read the telex, although the revocation was sent during business hours. The issue arose as to whether revocation had taken place when the telex arrived with the revocation, or when it was picked up and read. Ratio. The Court of Appeal held the withdrawal took place when it was received in the charterer's office, not at the point when it was read. Application. If a litigant could prove that his revocation of offer could have been reasonably read, then the offer is officially revoked when it is delivered. General principle. A unilateral offer can be revoked by publishing the revocation in the same method by which the offer was issued. All of the offerees do not need to read the revocation for it to be valid. Shui and United States, 1875. Facts. U.S. authorities placed an advertisement in various newspapers displaying a certain amount of money that would be paid as a reward in exchange for information leading to the arrest of a number of criminals. Later, the President of the USA released a proclamation that cancelled the reward, and once again this was publicized in the newspapers. After this advert had been published, Shui, who had seen the original advertisement but did not see that the ransom had been revoked, identified one of the wanted men and claimed the reward. Ratio. The Supreme Court held that, as the offer had been made through a general advert to the world at large, as opposed to him personally, he ought to have realized that it could be withdrawn in the same way. Application. Where there is an offer that can be accepted through a person's conduct, it is not clear what rules deal with the withdrawal. This is especially so with rewards and challenges, i.e., I will pay £1,000 to the first person here that cycles from London to Liverpool. General principle. When someone has begun to carry out the terms of a unilateral offer and keeps on doing so, the unilateral offer cannot be retracted. Errington and Woods, 1952. Facts. Mr. Errington purchased a house for both his son and daughter-in-law, Miss Woods, to live in. He paid £250 in cash and borrowed the remaining £500 from a building society. The house was registered in the name of the father. However, he said that as long as they paid the regular installments on the mortgage, he would transfer the house to them as soon as it had been repaid. 15 years after the father died, his estate brought action to seek possession of the house. Ratio. The Court of Appeal held that a unilateral contract existed. Woods and Errington were not obliged to keep paying out money, but if they did so because the father was obliged to transfer the house to them in accordance with his promise, that was acceptable. Application. Denning, L.J., said obiter that a unilateral contract cannot be revoked once the potential acceptor has started to perform their obligations under the contract arrangements. Revocation of a unilateral offer. General principle. An offer for a unilateral contract cannot be withdrawn if performance has been started or completed by the offeree. Dahlia and 4 Millbank nominees, 1978. Facts. Dahlia, complainant, wanted to buy a series of different properties from Millbank nominees, defendant. Inquiries were made and draft contracts were prepared. Millbank agreed that if Dahlia co-produced the draft contract and a banker's draft by a specific time, they would enter into a full contract with her. Dahlia obtained the banker's draft and submitted it to Millbank nominees' offices before the deadline. However, Millbank ultimately refused to proceed with the deal. Ratio. Brightman J. rejected Dahlia's claim for damages, as the collateral contract did not fall into line with Section 40 of the Law of Property Act 1925. However, Goff L.J. said obiter that while the offerer of a unilateral contract is entitled to require full performance of his condition and, short of that, is not bound, there must be an implied obligation on his part not to prevent the condition becoming satisfied, and that obligation arises as soon as the offeree starts to perform. Application. Until the offeree starts to perform, the offerer can revoke the entire offer. However, once the offeree has started to carry out the obligations of the agreement, it becomes too late for the offerer to go back on his offer. General principle. The terms of a contract may allow an offerer to revoke his promise, even after it has been partially accepted by performance. Luxor and Cooper, 1941. Cooper made an agreement with an estate agent, Luxor, that £10,000 would be paid to them if Luxor was able to find a buyer that would pay £175,000 for the land. The agreement between Luxor and Cooper was a standard agreement that could be expected from any seller and estate agent, that Cooper would pay the commission once the house was sold, and Cooper would not pay if a buyer was not found. Luxor found a buyer, but Cooper actually sold the land, 2 cinemas, to someone else. Luxor pursued Cooper for the fee, stating that they had fulfilled the contract. Ratio. The House of Lords held in favour of Cooper on the grounds that there was no reason to assume a responsibility by not revoking their offer. Lord Wright said obiter, "It is well recognised that there may be cases where obviously some term must be implied, if the intention of the parties is not to be defeated, some term of which it can be predicated that, it goes without saying, some term not expressed but necessary to give to the transaction such business efficacy as the parties must have intended." Application. It is more likely that the courts would agree with an argument for an implied term, if that term were reasonable. They will not imply terms into a contract just because it would be reasonable to do so. This is an important principle to remember when applying it to practical scenarios. A party that has carelessly made a very unfavourable contract will argue that some kind of implied term, which, if it were to exist, would make the contract fair. That, it must be understood, is not a good enough reason to imply a term. Lapse of time. General principle. Offers will expire at the end of the time stated for the lapse, if it's actually said, or after a reasonable time passes. Ramsgate Victoria Hotel and Montefiore, 1866. Facts. In June, the defendant made an offer to buy shares in the plaintiff's company. However, he did not hear back from them. Later, the plaintiffs decided to divide the shares of the company between people who had an interest in it in November, and claimed to accept the defendant's offer. At that point, however, the defendant did not want to go through with the deal. Ratio. The court said that, although the offer had not been formally withdrawn, it would expire after a reasonable period of time. Given the ever-changing nature of the subject matter, the time interval had gone beyond what was reasonable. Application. Ramsgate applies to many cases which deal with lapse of offers. The nature of the goods is critical in applying this case. Stock shares fluctuate in price within seconds, and so it would be incredibly unreasonable to assume that an offer for shares of a volatile stock would remain valid for days or weeks. If the goods were, say, furniture, the offer could remain open longer than what would be expected for electronic goods. Death of the offeree. General principle. Where an offer relies on the continuing existence of the offerer, the offer will terminate when the offerer dies. The offer will be unaffected by the death of the offerer in other cases, and can be accepted and will bind the estate. Reynolds and Atherton, 1921. Facts. In 1911, an offer to sell shares was made to the directors of a company. In 1919, an attempt was made by the survivors of the directors in 1911, and by the people representing the person who had died. Ratio. The supposed acceptance was held to be ineffective. Warrington L.J. said, "The offer having been made to a living person who ceases to be a living person before the offer is accepted, there is no longer an offer at all. The offer is not intended to be made to a dead person or to his executors, and the offer ceases to be an offer capable of acceptance." Application. If an offeree dies, the offer lapses, and living representatives are unable to accept. Death of the offerer. General principle. If the offerer dies and the offeree does not know about it, acceptance can still occur. Bradbury and Morgan, 1862. Facts. J. M. Lee asked Bradbury to provide credit to his brother. J. M. Lee later died, and Bradbury, who did not know of his death, kept giving credit to J. M. Lee's brother. The executors of J. M. Lee's estate, Morgan, claimed they did not have to pay because these debts were not sustained during J. M. Lee's lifetime. They claimed that these contracts were created while J. M. Lee had died. Ratio. Morgan was held liable for the goods purchased on credit. Application. A guarantee, i.e. being given an overdraft from your bank, is generally speaking divisible. The offer is continuous. It is accepted from time to time as the bank makes more loans to its customer. It appears that a guarantee of this kind cannot be established solely by the death of the guarantor. The offer continued to be an active commercial offer and, as such, the guarantee stood.